Welcome to CM Guide podcast series. Today, we're embarking on a fascinating deep dive into a really crucial area for anyone in the building and construction industry, especially if you're working in Western Australia. We're talking about security of payment legislation, its journey, how disputes are handled, and what it all means for you on the ground. This might sound like a technical topic, but its impact on cash flow, on fairness, and ultimately on whether businesses survive in construction is absolutely enormous. So if you've ever wondered how contractors and subcontractors in Western Australia actually get paid on time, or, what happens when a payment dispute turns ugly, you're about to get some incredibly valuable insights. We'll try and cut through the jargon and give you the essential knowledge you need to be truly well informed. Let's start with the big picture then. What exactly is security of payment legislation all about, and why is it such a vital cornerstone of the construction world? What was the situation like in Western Australia before the recent changes really shook things up?
Yeah, absolutely. It's a great question to kick us off. At its heart, security of payment legislation is designed to ensure that those who do the actual work or supply the materials in a construction project get paid and, critically, get paid on time. It's really about keeping the cash flowing smoothly down the contractual chain, preventing delays that can cripple businesses. Western Australia's story with this began with the Construction Contracts Act 2004, which actually came into play back in January 2005. That early act, well, it shared some goals with laws in the UK and New Zealand, but it had some pretty significant differences compared to, say, the New South Wales Act at the time.
Okay, so there was a framework in place, but clearly it wasn't quite hitting the mark, or things have moved on significantly. I understand there's been a massive overhaul recently. What triggered that kind of legislative earthquake, and what is the new law really trying to achieve?
You're absolutely right. It was a very significant overhaul, almost a complete reimagining, really. In June 2021, the old Construction Contracts Act was repealed and replaced by the Building and Construction Industry Security of Payment Act 2021. We'll probably just call it the WA Act from now on, makes it easier. This came after extensive consultation with the industry, listening to what was actually happening on site, what the problems were, and it finally aligned Western Australia's security of payment laws much more closely with those in other states, notably the New South Wales Act. The key provisions of this new WA Act, they apply to construction contracts worth $20,000 or more, specifically those entered into on or after August 1st, 2022. It also directly incorporates many recommendations from major independent review reports, like the Murray Report and the Fiocco Report, which really highlighted where the old system was failing people.
Right, I remember those reports making waves. So for someone listening, maybe a head contractor or perhaps a subcontractor, what does this alignment, this new WA Act, mean in practical terms? What are the game-changing improvements or protections you'd point to?
Well, the primary goal, the real driving force behind this, is to provide much stronger protections for subcontractors and suppliers. They're often the ones most vulnerable to cash flow issues. For instance, the ability for a principal, the project owner, to lodge an adjudication claim against a head contractor or head contractor against a subcontractor, well, that no longer exists under this new law. It's focused down the chain. And the Act introduces a statutory right to payment. This is huge. It means you have a legal right to be paid for your work, quite separate from what your contract might say.
Okay, so it overrides potentially tricky clauses.
Exactly. It effectively overrides those clauses in some contracts that could be used to hold up payment unfairly. It also brings in significantly shorter payment intervals. Progress payments are typically due within 25 days or less. And for residential projects, it can be as short as 10 days if no specific date is given in the contract. Much quicker.
That's a big difference.
It really is.
Yeah.
And another game changer is the deemed trust scheme for retention money. Before, if a head contractor went bust, that retention money often just disappeared with them, leaving subcontractors high and dry. Now it's meant to be held separately, acting like a protective shield for those funds.
So it's ring-fenced, essentially.
That's the idea. This trust scheme initially applies to contracts over $1 million, but it's set to extend down to contracts over $20,000 from February 2024. And there's also increased authority for the Building Services Board, which kicked in from February 2023. They can now take action against registered builders for non-payment or signs of financial instability. They even have the power to exclude them from operating. So, real teeth.
Wow, okay.
Ultimately, it's about fundamentally rebalancing financial risks and promoting far fairer contracting practices across the whole sector.
Okay, let's unpack this a bit more. Let's imagine, say, Sarah, a small plumbing subcontractor. She's just finished a big job. A new contract is in place. Under the new act, work is done. How does someone like Sarah actually make a claim for payment under this new streamlined system? What does a payment claim look like now?
Right, good example. For Sarah, or anyone in her shoes, a payment claim is her formal request for a progress payment. It's the key first step. She can make it after specific periods, often monthly or whatever is stipulated in her contract, and she must deliver it directly to the party responsible for paying her, usually the head contractor in her case. Now, to be valid and hold up under this system, it must be in writing. It needs to clearly state the amount she's claiming. It has to describe the construction work or services she's provided, and critically, like we mentioned, it has to explicitly state that it's made under this act.
That phrase is vital then.
Absolutely vital. It flags it under this specific legislation. It can even be a standard invoice, provided it contains those key elements. And just a side note, if it's for home building work above a certain value, a special homeowner's notice might also be required when she submits it to the principal, unless certain exceptions apply.
That makes sense. But what if the party receiving Sarah's claim, let's say the head contractor, disputes it? They don't think they owe that much, or maybe not yet. Is there a formal way for them to respond rather than just, ignoring it or dragging their feet?
Yes, absolutely. And this is where the payment schedule comes in. It's the respondent's turn. The party receiving the claim, the respondent, has a crucial opportunity, and obligation really, to provide a payment schedule back to Sarah. This has to be done within 15 business days of receiving her payment claim, or even earlier if their contract specifies a shorter time frame. Time is of the essence. The schedule must clearly identify Sarah's claim. It has to state exactly how much the respondent intends to pay, which of course could be zero. And here's the really crucial part. If the amount they intend to pay is less than Sarah claimed, or if they propose to pay nothing, they must clearly explain why. They have to outline very specific reasons for withholding any payment. No vague excuses.
Okay, so clarity is key on both sides, but what happens if the respondent just doesn't provide a payment schedule by that deadline? Or perhaps they provide one, but then they don't actually pay the amount they said they would. What are Sarah's options then? What can she do?
This is a critical juncture, because the consequences for the respondent are pretty significant under the Act. If they fail to provide a payment schedule within the allowed time, they automatically become liable to pay the claimed amount in full. Simple as that.
The whole amount.
The whole amount, Sarah claimed. They also lose the right to submit an adjudication response later if it goes that far. And they can't just invent new reasons for withholding payment down the track.
Right. So it really incentivizes them to respond properly and on time.
Exactly. It encourages parties to be upfront and responsive from the get-go. Now, if they do provide a schedule, but then don't pay the amount stated in that schedule, or if they pay less than scheduled and Sarah disputes it, she then has two clear, distinct options. She can either pursue the unpaid portion as a straightforward debt in court, or she can make an adjudication application under the Act.
And she has to choose one or the other.
Yes, she can only choose one of those paths for that specific claim.
You mentioned earlier something about pay-when-paid clauses being prohibited. How does that fit into this whole mechanism, especially with these options for Sarah?
Yes, that's another huge protection baked into the Act. It explicitly states that any pay-when-paid provision in a construction contract has absolutely no effect. It's void.
So Sarah gets paid regardless of whether the head contractor has been paid by the principal.
That's the principle. She is entitled to payment for her work based on her contract and the Act, regardless of whether others further up the contracting chain have received their money. This also extends to other tricky terms that might try to force parties into, say, complex internal dispute resolution processes before they can even issue a payment claim or apply for adjudication. Those types of barrier clauses are also prohibited, removing common roadblocks to getting paid.
Okay, this seems much clearer and more powerful for the claimant. Now, here's where it gets really interesting, I think. If payment isn't made and Sarah decides not to go straight to court, she can apply for adjudication. Can you walk us through how that process works? Who are these adjudicators and what exactly do they do? It sounds a bit like a mini trial, but maybe not.
Yeah, it's designed to be much quicker and less formal than court. If Sarah chooses adjudication, she makes an application. She can apply either to an adjudicator specified in her contract, though that's less common now, or, more typically, she applies to an authorized nominating authority, or ANA. These are independent bodies authorized by the government. And importantly, Sarah gets to choose which A&A to use. She isn't bound by any contract clauses that try to restrict her choice.
Giving her some control.
Exactly. Her application is a written submission, usually on an approved form. It needs to include her original payment claim, any payment schedules you received, relevant bits of the contract, and her arguments and evidence. A key point is that the adjudicator's appointment is formalized once they accept the role, and this acceptance must happen quickly, typically within 5 business days of the A&A receiving the application. Speed is crucial.
And once an adjudicator is appointed, how do they actually go about deciding the dispute? What's their process like?
Right, so the adjudicator's job is to make a determination that's fair, prompt, informal, and cost-effective. That's their mandate. They have quite broad powers to achieve this. They can ask for more written submissions from either Sarah or the respondent. They can set deadlines. They can hold informal conferences, maybe over the phone or video call to clarify points. They can even inspect the site themselves if they think it's necessary.
So not like a formal court hearing with wigs and gowns.
Definitely not. They aren't bound by strict formal rules of evidence like a court. It's a much more flexible and pragmatic process focused on the substance of the dispute. Now, crucially, if the respondent initially provided that payment schedule we talked about, they can submit an adjudication response. They get 10 business days after receiving Sarah's application to do this. But here's the vital catch we mentioned earlier. They cannot introduce new reasons for withholding payment in their response that weren't already clearly stated in their original payment schedule.
So they can't ambush Sarah with new arguments at this stage.
Precisely. It really pushes parties to put all their cards on the table right at the payment schedule stage. It encourages transparency and avoids delays. This is a significant improvement over how things sometimes worked before.
Okay, that makes sense. But what if during this process, the adjudicator looks at everything and thinks, hang on, I don't think I actually have the power to decide this under the Act. Or maybe they think Sarah's application itself isn't serious, or it's just way too complicated for this fast-track process.
That's a vital safeguard built into the system. An adjudicator must first assess their own jurisdiction, basically asking themselves, do I have the legal power under this specific act to hear this specific case? If they determine they lack jurisdiction, or if they find the application to be, in the Act's terms, frivolous, meaning trivial or lacking substance, or vexatious, maybe designed just to annoy or harass the other party, or just too complex to resolve fairly within the strict timeframes.
Which are pretty tight.
Very tight. If any of those apply, they must state this clearly in their determination. They'll explain that because of this issue, no payment is due under the adjudication process. But assuming they do have jurisdiction and the claim is valid, their final decision, the determination, details the exact amount of progress payment they've decided is owed, the date it's due, and any interest payable. It has to be in writing, it has to give reasons for the decision, and it gets shared with both parties and also lodged with the building commissioner. The whole point is a quick resolution, so they aim to issue this determination within 10 business days after receiving the respondent's response or after the deadline for that response passes if none is submitted.
10 business days is fast. So an adjudicator has made a determination. Is that the absolute final word? End of story? Or is there a way to challenge it if one party, Sarah or the respondent, feels it's just plain wrong? This seems like a high-stakes decision made very quickly.
You've hit on a really interesting and commendable feature of the new WA Act, the adjudication review mechanism. This wasn't in the old Act. Commentators suggest this provision was actually the direct result of extensive research, including, believe it or not, a PhD thesis that highlighted the critical need for some kind of internal review process within the security of payment framework itself.
Really? A PhD?
Yeah, it shows how much thought went into this part. The whole idea behind it is to keep things moving, facilitate that swift cash flow, and maybe deter respondents from immediately running off to court just as a delaying tactic, which can happen. It acts as a crucial safety net, really, to catch potentially significant errors in determinations before involving the traditional court system. The aim is to build industry confidence in the adjudication process itself.
That sounds like a genuinely significant development. So who can actually seek a review and under what specific conditions? Does any disagreement qualify or are there limits? You mentioned thresholds earlier.
Good question. No, not every disagreement qualifies. Either the claimant, like Sarah, or the respondent, can apply for a review of an adjudicator's determination, but they must meet very specific criteria and apply quickly within 5 business days of receiving the determination. For a claimant like Sarah, she can apply if the amount the adjudicator determined is significantly less than the amount she originally claimed. The gap has to be a minimum of $200,000.
200,000, that's a big number.
It is. Or, alternatively, she could apply if the adjudicator ruled they lack jurisdiction altogether, but only if the amount she originally claimed exceeds a certain regulatory threshold, which is currently set at $50,000. Conversely, a respondent can seek a review if the amount the adjudicator awarded is significantly more than the amount they offered in their payment schedule again by that same $200,000 threshold. But they can only do this if they actually provided a payment schedule in the first place and met certain conditions.
Okay, that $200,000 threshold is quite high, as you say. What does that mean for disputes where the difference is, say, $50,000 or $100,000? Are they just stuck with the adjudicator's decision unless they go to court?
You're right, the threshold is significant. And yes, commentary suggests that for disputed amounts below this high threshold, the main path for challenging the substance of the adjudicator's decision often only lies via traditional and potentially much more protracted and costly legal proceedings in court.
So the review is really for the bigger discrepancies.
Primarily, yes. Now, for a respondent who does meet the threshold and wants to seek an adjudication review, there's another crucial precondition, and it's a big one. They must first pay any undisputed portion of the adjudicated amount directly to the claimant, and the disputed portion of that $200,000 or more difference must be paid into a designated trust account.
Ah, so they can't just use the review process to delay paying everything.
Exactly. Those funds are held securely, basically in escrow, for the claimant's benefit until the review adjudicator makes their decision. It stops the respondent from simply tying up all the money during the review.
This raises an important practical question, though. If there's this specific review mechanism built into the Act, can parties still just decide to bypass it entirely and go straight for a judicial review in the Supreme Court if they think the adjudicator made a legal error?
That's a very pertinent point. The Act is actually silent on whether parties must exhaust this internal review mechanism before seeking judicial review from the courts. This silence means that, in practice, parties with, shall we say, deeper pockets, or those who strongly believe there's been a fundamental jurisdictional error, might still choose to go directly to the Supreme Court to challenge a determination.
And potentially avoid having to pay the disputed amount into trust first.
That could be a strategic consideration for them, yes. However, the Supreme Court does have the established authority to set aside an adjudicator's or even a review adjudicator's determination if it finds a jurisdictional error. This means the adjudicator made a decision outside the legal powers granted to them by the Act, essentially acting ultra vires or beyond their power.
What kind of things count as jurisdictional error?
Well, it can include situations like a clear denial of procedural fairness. For instance, if one party wasn't given a fair chance to present their side of the story or respond properly to a key argument raised by the other side, it's expected that legal precedents from other states, particularly New South Wales, where the model is similar, will likely be quite influential as Western Australia's courts begin to interpret and test the boundaries of this new act.
So even with the internal review option, court intervention remains a possibility, especially for these larger or more legally complex disputes. If a review does happen internally, what's the goal of the review adjudicator? What can they actually do?
The review adjudicator has two clear options once they take on a case. They can either confirm the original adjudicator's determination, essentially saying, yes, looking at this again, the original decision was correct under the Act. Or they can overturn it, quash the original determination, and issue a brand new determination themselves. If the original decision is quashed, the review adjudicator then decides the new payment amount and any interest that should apply. And if an excess amount was paid by the respondent based on that now overturned original ruling, because remember they had to pay undisputed amounts, that excess must be repaid, usually with interest.
So it aims for a final, robust decision within the system.
That's the goal. But it's important to note, the Act doesn't give the review adjudicator power to award legal costs for the review process itself, or to change the fees charged by the original adjudicator. Those aspects are separate.
Okay, this whole system, adjudication and review, relies so heavily on having qualified, impartial individuals making these calls. How are the authorized nominating authorities, the ANAs you mentioned, and the adjudicators themselves actually regulated and appointed? What gives them legitimacy?
Yeah, that's crucial for trust in the system. The building commissioner plays a central regulatory role here. ANAs, those bodies responsible for appointing adjudicators if one isn't named in the contract, must apply to the commissioner for authorization. And once authorized, they have to adhere to a strict code of practice. This code covers all their duties, ensuring they comply with the Act, maintain a duty of care, act honestly and fairly. It explicitly prohibits them from trying to influence how an adjudicator decides a case or accepting any kind of inducement. Integrity is paramount.
And what about the adjudicators and review adjudicators themselves, the people actually making these critical decisions? What does it take to become one, and how are they held accountable?
Individuals wanting to be registered as an adjudicator or a review adjudicator must apply directly to the building commissioner and meet several pretty strict criteria. This includes possessing specific qualifications and expertise. Often, that means having a degree from an Australian university or an equivalent qualification from overseas in relevant fields like architecture, engineering, quantity surveying, building and construction, or law. They also generally need to complete an approved training course on the Act and adjudication practice.
So they need the right background and training.
Definitely. And they also must have a clean record, not have had a previous registration, suspended or canceled, no serious criminal convictions, not be recently bankrupt. The regulations even categorize adjudicators into Grade 1 and Grade 2. To be a Grade 2 adjudicator, which allows handling higher value or more complex claims, you generally need experience in a certain number of determinations already, especially those over $50,000. And like the ANAs, they also operate under their own detailed code of practice, which absolutely mandates independence, impartiality, confidentiality, and professional conduct. And just underscore the legal aspect, for specific jurisdictional matters that might come up in a review application, the review adjudicator must be a qualified lawyer.
That makes sense, given the potential legal complexities. So what does this all mean for the costs involved in this entire process? We're talking about the adjudicator fees themselves. Who ends up paying for that?
Right, the cost question. Adjudicators and review adjudicators are entitled to be paid fees and expenses for their work. This can either be an amount agreed directly with the parties involved, or it's set at rates approved by the building commissioner, and these are subject to maximums set out in the regulations. Now, as for who pays, both parties, the claimant and the respondent, are jointly and severally liable for these fees. That means the adjudicator could technically recover the full amount from either party.
But how is it usually split?
Generally, the starting point is that they contribute equally, 50-50. However, the adjudicator does have the discretion to adjust this split. They might decide one party should pay more based on factors like their conduct during the process, were they unreasonable, did they cause delays, or based on their relative success in the adjudication, did one party largely win.
Okay, so conduct matters.
It can. But it's important to remember that each party typically bears their own legal costs or costs for consultants they hire to help them beyond these specific adjudication fees. The adjudicator generally doesn't award those costs. And one final point on fees, an adjudicator can actually withhold their determination until their fees are paid, provided they've issued a proper invoice before the determination deadline. If they do this, it effectively extends the time frame for them to make the decision until that payment is made.
A practical mechanism for them to ensure they get paid too.
Indeed.
Okay, so we've taken a truly comprehensive deep dive into Western Australia's security of payment legislation. We've covered its origins, the drivers for the big changes, the nuts and bolts of payment claims and schedules, the adjudication process, the new review mechanism, and even the regulation of the people involved. So, pulling it all together now, what's the biggest, most actionable takeaway for our listeners out there navigating the construction industry day to day in Western Australia?
I think the key takeaway is this. The WA Act fundamentally aims to create a much fairer and significantly more efficient system for ensuring timely payments right through the construction supply chain. That's its core purpose. It provides powerful statutory rights you have by law, not just by contract, and a deliberately streamlined process designed to resolve payment disputes quickly. It really does bolster protections for subcontractors and suppliers, like our example, Sarah. So understanding these mechanisms, from the absolute critical importance of getting your payment claim right, making sure it says under this act, to understanding the payment schedule deadlines, and knowing how to use the adjudication and potentially the review processes is absolutely crucial for anyone involved in a construction contract in WA now. It's really about knowing how to leverage these powerful legal tools to secure your cash flow, manage risk, and ultimately ensure fairness in what can be a very tough industry.
Sound advice. And perhaps a final thought for you, our listeners, to mull over. While these new laws provide robust protections and much clearer pathways for resolving disputes than before, the legal landscape is always evolving, isn't it? Especially when legislation is relatively new, like this WA Act. How might the ongoing testing of this act in the Western Australian courts, the challenges, the interpretations, the precedents being set, how might that further shape its real-world interpretation and impact on the construction industry in the years to come? Something to watch. The story isn't over yet. Thank you so much for joining us on this deep dive into security of payment in Western Australia. We really hope this exploration has given you a clearer, more practical understanding of this vital area. Before you go, please don't forget to share, like, or subscribe. Also, have a look at other episodes and visit CM Guide website for better insights on this topic.